Everyone, I'm Barbara Simmons, Chair of the International Law Session, and it's our pleasure to welcome you this afternoon to our second CLE for this convention. It will be a round table or a square table, however you might want to refer to it, discussion on numerous topics. And so I'll first introduce, well, I'll just have to wave to you essentially our speakers, and then we'll begin with our first panelists. So we have Vanita Banks, who is past president of NBA. Ms. Banks. We have Leroy Wilson Jr., who is a life member of NBA and who currently resides in Botswana. Then we have our honored guest, Ms. Patience Okala, am I saying it right? From the African Continental Free Trade Area. We were just treated to a wonderful keynote presentation on the AFCFTA. And we have Johanna LeBlanc, who is, I call her this brilliant visionary genius who, to me, her greatest characteristic, though, is that she's a sharing, caring person. So, Ms. LeBlanc. So with that, we will begin with the presentation by Ms. Banks, who will give us an overview of global AI. It's been a long couple months, but in any case, Ms. Banks.
Thank you so much, Barbara. Let's give Barbara another round of applause for her vision and leadership. Thank you so much for your leadership of the International Law Section. We really appreciate you, Barbara, and thank you so very much. And I'm sitting down. Can you hear me, though,
yes.
however?
Yes.
Okay?
Yes.
Because those of us who are still workers in the NBA, right? I've had like 3 meetings today and got here on Friday prior to our civil trial advocacy boot camp that ran from 9 a.m. to 5 p.m. on Saturday. And my colleague here, he attended the boot camp, and he will tell you that the first seminar, the first panel was entitled The Power and Responsible Use of Artificial Intelligence. And we know that that is necessarily a global conversation because it is imperative that while we harness the power of AI, that we also address the tremendous risk associated with AI. And when you hear U.S. CEOs writing a letter stating that AI has the potential to make life better or to destroy the world. You know, so these are the folks, when we look at, you know, these corporations like the Microsofts and the Googles, et cetera, the Brad Smiths of the world, et cetera, when they're sitting at tables like this, they're saying that there are risks that necessarily need to be managed. I don't know if you watch 60 Minutes, for example. I was watching it a couple weeks ago, and there was the gentleman who is referenced as the, quote, father of AI, and he was asked the question whether or not the artificial intelligence, those robotic, automated systems, could they become smarter than humans? What was his answer?
Yes.
He said yes. Mm-hmm. Okay. And let's go back to 1957. Alan Turing is the father of computers in this country, and he wrote an article entitled, "Can Machines Learn?" What was the answer?
Yes.
Yes. So while, and I'm just going to skip through some of my thoughts here. While AI is diagnosing cancer and facilitating early treatment, while AI has determined the structure of over 200 million proteins, while AI through drones, and we talked about this during our boot camp. Drones is an AI powered tool, while AI drones are being used in accident construction cases, also delivering much needed medication in Africa and other countries. There are incredible risks that as lawyers we need to be at the forefront of addressing. We need to make sure that that we're at the table, right? And we need to make sure that we're developing and making our own table. You know, Shirley Chisholm said that if there's not a table, if there's not a chair for you at the table, then you bring your own chair. I'm saying let's create our own table because we need to be informing the development globally of these AI systems to ensure against discrimination and bias, which is already being built into some of these systems. African American men are being racially profiled. We talk about facial recognition and these biometric systems. We're already being, discriminated against. And so we have got to ensure that we have diverse professionals at the table actually informing these systems, right? Because otherwise, globally, we are going to be facing some very, very dire, circumstances. So I focused my career at the intersection of law, technology, and public policy. And throughout my career in the insurance, financial services, and pharmaceutical sectors, I've advised and counseled information technology professionals. These are the people that are building these systems, right? So I've focused my career sitting side by side with them as a legal partner, advising them on the legal requirements of those systems that they are building. That was pre-AI and actually taking our business on the internet. It's only been about 40 years, okay? It's only been about 40 years that professionals had desktop computers, right? It's only been about 40 years. And so on a daily basis, I counsel information technology professionals on developing and implementing systems to achieve their business objectives. And formerly, many of you know, we were talking about mainframe systems, but now everything is moved to the, quote, cloud, right? And so, but while everybody tends to say that, AI is new, and we say that because in November of 2022, ChatGPT was introduced. But AI systems have been around for a long, long time. For example, the insurance industry, which I'm a over 20-year executive with Allstate Insurance Company. The insurance industry has long used big data sets, we call them, and algorithms in the underwriting of insurance risk based on predictive analysis. That's what these AI systems do. They make predictions based on input that has been entered in those systems, currently by humans, right? But let me go back up and say as well that we've heard the term garbage in, garbage out. So those systems are as proficient as those individuals that are inputting the information or the data into those systems. That's why we need diverse data scientists. And we need to have STEM programs and pipeline programs that introduce our young people to the importance of STEM careers. What is it? Science, technology, engineering, and math. Because that's what this is all about. And so we have to make sure that as lawyers, we're at the forefront of developing policy, and we have to make sure as well that we are ensuring that our young people have access to STEM education. And so Let me just kind of again, to set the historical context, over a century ago, in 1897, U.S. Supreme Court Justice Wendell Holmes wrote, "For the rational study of the law," and we're talking about, the lawyers in the room understand, the black letter law, that's the law of the present. He said this in 1897, but the law of the future is the law of statistics. And so AI, this type of thought, it's been around, for a long, long time. In terms of the practical practice of law, and our CLE was focused on it on Saturday, there are many, many AI-powered tools that are being used in law practices today. Some of your Microsoft software that you already have on your computer, as well as LexisNexis, are you aware that there are tools right there for free that enable you to develop first drafts of briefs, table of contents, and tables of authority? AI-powered tools are being used for contract review. They're being used for document review, legal research, compliance, and due diligence. And again, generative AI, that is the ChatGPT, that's a game changer, particularly for small firms, because it enables you to have right at your fingertips the ability to digest cases, come up with a draft of a brief, at the same time that these big law firms, what are they doing? They've got like 100 associates, right, that are preparing, their litigation as well. So it enables, it's really a game changer for solo and small firms, because you're able to compete right there with them. And guess what's going to happen? Those 100 associates that are currently doing all that research, what's going to happen? In the future, those jobs may well be eliminated. Now, again, as leaders of the legal profession, our role is to ensure that AI is used for the benefit and good of society and to guard against the potential bias and discrimination, but it must be regulated. And that's where those of you that specialize in public relations, we're needed to ensure that there is global regulation, and there's a need for what I call harmonized global legislation, and we need a global framework that ensures the safe and secure use of AI. And I just want to reference the UN, this is the global panel, the recent UN resolution. Their title of that resolution is the same or very similar to the Biden administration executive order in terms of the framework that they are, establishing. The UN resolution is called Seizing the Opportunities of Safe, Secure, and Trustworthy AI Systems for Sustainable Development. And that's the first AI resolution adopted by the UN. And the Biden administration, by comparison, their executive order is also entitled On the Safe, Secure, and Trustworthy Development and Use of AI. So right now, globally, governments, let me just tell you this, over 800 international and domestic governments in more than 69 countries have enacted or are considering enacting AI legislation. In the United States alone, over 491 state legislatures have proposed AI legislation in the first 3 months of this year. also wanted to share that very quickly, and I will close. There are 7 countries, I'm not finding my notes right this moment. Yes, 7 African nations have drafted AI strategies, but Benin, Egypt, Ghana, Mauritius, Rwanda, Senegal, and Tunisia. They're not finalized, but they've introduced, those are the 7 countries as of last time that I checked that have AI policies that they are developing. Also, with respect to the of course, the AFCFTA identifies cybersecurity as a priority and flagship project. And another organization is the OECD AI. It is a forum where countries come together to shape trustworthy AI, and it served as a basis for the G20, one of the guidelines for the G20 principles. And so, just in wrapping up, global coordination is the only way to harness AI for humanity and guard against the risk. And you might ask, okay, because Barbara told us that these conversations would be focused not on the issue, but about, what we all can do. And so what we can do is familiarize ourselves with these AI-powered technologies. Many of them are free at no cost to you. I mentioned some of them are on your desktop computers already. We should familiarize ourselves with these, laws and regulations, the executive order that I mentioned. And I haven't talked too much about the EU AI Act, which was recently enacted as well. And that's based on the Global Data Protection Regulation, also known as GDPR. But the things that we can do is to make sure that we are becoming familiarized with this technology, that we're using this technology, and understanding that if this presentation was made in 2 months, it would all be changed, right? Because it's evolving so quickly initially, and the technology is evolving faster than the law. And so as lawyers, in terms of the legal profession, we're like one of the last bastions of not wanting to change, right? But we have no choice in this era. And thank you for the opportunity to share a few words with you this afternoon.
Thank you for that past president thing, and now we'll have Leroy with us.
Good afternoon, ladies and gentlemen.
Good afternoon.
The reason that I am up here is because I have a tendency sometimes to not project my voice. And for me, it's 11 p.m. So I want to be sure that you'd be able to hear what I had to say. Now, how many of you, just to get an idea, how many of you have heard of C.L.R. James? Okay. He wrote this book, and if you're interested in the history of Haiti, what has happened to Haiti and what is happening to Haiti, a lot of it is in this book. the black Jacobins. You can pass it around for me. Now, since our theme is lawyer preparations for addressing addressing critical current and developing international issues, I'm going to discuss some of the issues you will encounter if you decide to look into suing the Republic of France and its co-bad actors such as Citibank and the United States for the harm they've caused to Haiti. I was going to read 2 paragraphs out of the book, but I'm going to skip those for now. But let's say that you're sitting in your office at 6 p.m. and you receive a telephone call from a lady who tells you that in 1914, 1915, Citibank took $500,000 out of Haiti using a cordon of United States Marines. And she wants to know if you might be able to take some sort of action against Citibank. Now, Juice, what was his name?
Oh, Mr. Juice.
Gary Juice said that it was taken out in the form of gold, but it doesn't make any difference. The $500,000 value at that time is now worth $15,862,071 using Bing AI. At the same time, the person tells you that there's an article that she read in the New York Times about valuing how much Haiti lost as a result of France charging reparations, which they call a double debt. First, because France required Haiti to pay reparations as an indemnity for the loss of their property, the property being the loss of slaves, and that some calculations have been made in terms of how much economic development Haiti could have had that money remained in the country. And so the numbers that they've come up with is anywhere from $21 billion to $115 billion. And so that gets your interest because of the money that's involved, because of the issues that are involved. And then the question is, well, how do we proceed? I'm just going to use 2 cases that I was involved in and the things that we learned from both of those cases. And I'm going to give you the citations for both of those cases in case you want to take a look at them later. The first lawsuit that we filed in this case, and when I say we, I mean Godfrey L.L.M, who was a very close friend of mine and who had formerly been the Attorney General of Uganda when it became independent, and later an interim president. So, and I call him Godfrey, so that's what I'm going to call him here. So Godfrey and I filed a lawsuit against the United Nations because what happened is after the government in Somalia fell in 1991, the United Nations sent in a humanitarian force to distribute aid and comfort to the people of Somalia. That was called Unisom 1. And then as things developed, they had to send in some armed troops, and that evolved into Unisom 2. But what happened is the Unisom forces, along with U.S. forces, occupied a 1 square kilometer compound, let's say, in the middle of the city of Mogadishu, which is owned by Abdi Hash Askia, who was the man that we represented. He had a city within a city, independent power generation, office buildings, hotels, restaurants, and so forth. So they simply took over that property. Now, what we were trying to do is to come up with a theory of recovery ordering some compensation for the use and occupancy of that property. And we came up with a number of about $190 million. So, to make a long story short, with respect to litigation, I'll say a couple of things. We started the case against the United Nations, and the first step was, well, how do you get service on Boutros Ghali, who was the Secretary General at the time, and Godfrey knew somebody who worked within the United Nations who actually served Boutros Ghali. Now, in that case, which was filed in the United States District Court for the Southern District of New York, the United States came in and told the judge that there was some kind of security interest involved and that the case should be dismissed. Judge Cotto congratulated us on bringing something other than a mundane day-to-day operation type case. He was very happy to get it. But eventually, he dismissed the case. And while we were developing that case, we also came up with the theory of suing the United States. And we couldn't sue the United States in the district court at that point because we were suing, saying basically that the United States had confiscated this property, or the use of the property, by taking private property for public use without compensation. The first citation, if you're interested in it, in the U.S. District Court for the Southern District of New York, is at 933 Fed Sup 368, 1996. And the case in the United States Court of Federal Claims has a case number of 96-351L. When you look at the case, I couldn't find, given the resources that I had at the time, I could not find the Fed Sup case online. So I don't know what they listed there as the attorneys, who they listed as the attorneys. But after Judge Cotto dismissed our case, Mr. Hodge fired us. And at that time, we also had the case pending in the United States Court of Federal Claims. He then hired a gentleman named Philip Mussolino. And so what you will see in the opinion in the United States Court of Federal Claims is that the attorney for the plaintiff is listed as Mussolino. But if you go back to the original filing, you'll see that we filed that claim. And initially, in the U.S. Court of Federal Claims, the Chief Justice had the case. He held on to it for quite a while, and then he gave it off to another judge. And that judge took, I think, there was a total of about 3 years before that judge made a decision. He also dismissed the case. Now, the importance of these two cases is that what they essentially say is that if you've got to distinguish between whether the government is functioning as a sovereign or in some commercial capacity to come within the provisions of the Federal Sovereign Immunities Act. But in the case in the United States Court of Federal Claims, the court said that the action taken in Somalia was taken in a sovereign capacity and not in a commercial capacity. Moreover, Mr. Hodge was a non-citizen, non-resident, didn't have the connectivity with the United States, and the property was located outside of the United States. And so that becomes relevant in terms of looking at France, deciding, well, if you can sue France, where are you going to sue them? If you sue them in the United States, which courts are you going to use? And as a practical matter, you are left to the federal courts, because if you file in state court, France is going to move immediately to remove the case to the federal court, so that's where you're going to be. So the question is, who are going to be the parties? And I think that maybe one group that could be a party would be a group of people who are resident within the United States, who have a connection with Haiti that the United States recognizes. And then you sue and you recover. The question then is, well, if you recover money, what happens to it? This was a question also that Gary asked the other day. And he said, well, you'd have to set up a trust of some kind. Now, after...
Set up a what?
Trust. After trust,
No, you said set up a what?
a trust.
Oh, trust.
Trust,
You
yeah.
mentioned trust, Leroy.
Right.
What about a compensation fund?
Well, whatever you call it, the question is, who is going to manage the money?
Exactly.
So, I thought about that, and what I thought about is that at least I would entertain the prospect of asking the African L.L.M Bank, I always get this mixed up too, let me just say the African Export-Import Bank, instead of saying the Afro-Exim Bank. So either getting that bank or the African Development Bank to set up a trust division, to act as a trustee in these situations where money might be recovered on behalf of a population of a country. And the reason for recommending those two is, first of all, they have very strong balance sheets. Secondly, they have good reputations for managing money. And so I would at least ask them and see what they have to say. You might even have a protocol on that. Now, I was interested in whether or not anybody had tried to sue France to recover the money. And the reason I'm raising all of this is because somebody talked about proceeding one brick at a time. Our cases were dismissed, but somebody will come up with a theory that will not be dismissed and will be decided on the merits at some point, I hope. And of course, if you recover $21 billion to $115 billion to assist the people of Haiti, that will go a long way. Now, I asked one of our colleagues about whether she knew about any cases where somebody had actually sued France and what happened. And the person assured me that, yes, there were many, many lawsuits. They were all dismissed. And I asked to send me the information. I never got it. So in the absence of that, I did, which is the next best thing, and that is the United States Law Library, the Library of Congress, has a law library, and they have a feature which is called Ask a Librarian. And so a few days ago, I sent a request. There were 3 questions, which I won't repeat here, but you can read them if you're interested in them. And just today, as I was sitting over there a few minutes ago, I read the response. And so they've given me a list of citations, which I take a look at as a matter of general curiosity and general interest. But, so something's been done. And given the kinds of hyperlinks that I see here, it means that there's been a lot of activity in this area. Now, France right now is particularly vulnerable, I think. First of all, because you just had the upsetting elections in France. And secondly, because of what's happened in the Sahel. The government of Niger, with the new military government, took the position that France was not paying a fair price for its uranium. I forgot exactly what the numbers were, but there was something like France was paying 2 cents a kilogram for uranium under the president who was in office at that time. And they immediately raised the price, I think, to about $2,000 a kilogram. And there were some other things that they did.
How much
But-
was it on the open market?
Huh?
If you bought it in the open market, how much would the United States pay?
I'm sorry?
How much would the United States, how much would the...
Oh, I have no idea. But I know that France is very heavily dependent upon uranium from this year. So,
They still steal.
Well, I don't know what mechanism they have to enforce the prices they charge, but they want to keep their lights running, they gotta get the uranium. And they've been getting it from this year, so I think that they'll be able to get the price that they want. So that is just a brief overview of this issue. I want to say that the New York Times did a very extensive article on how and why we calculated the value of Haiti's payments to France. Now, once again, and these guys spent a lot of time on this, gathering this information. They went a lot of places to get it. Why did they get it? Now that they do have it, you know, this can be discovered. And I think maybe they have more information now than they had in the past, and so that could be useful. The last thing is, there was an article written by a man named Weston Lee Alstonot, which is called The Case for Haitian Reparations. Once again, a very learned article, spent a lot of time making the case, and if they're spending all this time trying to find out how much money Haiti is owed, we're in the business of trying to recover money for people, and it seems to me that this is, you know, proof of error that one can examine. There is one last thing, and always with last things, you know, I've forgotten what it is. Take a look at my outline here. Oh, I know what it is. So, the kinds of jurisdictional problems that, you know, might arise in suing France, you don't have with respect to Citibank. I thought it was rather ironic that there was a report in the news yesterday which says that that Citibank is exiting Haiti after being there for 50 years. Well, it's been way more than 50 years that Citibank was there. You know, Citibank, the United States State Department, through Citibank, was running Haitian finances way back in around 1914, 1915. But, so, of course, you've got to overcome certain kinds of offenses. They're going to say, well, there's latches, statute of limitations is run, and so forth and so on. But we have to exercise our creativity to overcome those kinds of offenses. So that is all I have to say.
Leroy, I have a question. You were talking about what are some of the barriers or potential barriers to such?
Let's take the questions as soon as I just do the summary of your two presentations. So we've heard from two of our panelists. If I'm interpreting right, Ms. Banks is indicating that the artificial intelligence is something that we need to be proactive about, and it's not a matter that we can ignore it. Either we get on board and grab hold to it, or we're left standing at the station while the train or plane or whatever it is will have taken off. Then Mr. Wilson's presentation, and for those of you that weren't with us this morning, we had a wonderful presentation on the issue of Haiti. And so one of the things I had told our planning committee was that we always wanted to give people action steps or suggestions as to how you go to the next level with it. So Mr. Wilson has presented, if you thought about undertaking litigation, what are some of the obstacles you might come across. But I think the message is also, though, that if France and others are expending energy finding out what the status is in terms of the impact on Haiti, then obviously there is some impact, and there is that potential for us attempting at least to find out, well, what kind of reparations can we litigate to receive. So that gives us food for thought. Now, the second part of our panel is going to consist on a focus of the African Continental Free Trade Area. But I'm willing, if at this point we have questions related to our first two panelists, to take those questions, and then we'll go into the second part. So you had a question, Ms. Banks?
In terms of those theories of recovery, Leroy, I was wondering,
Is there a microphone?
in terms of those theories of recovery and those defenses, have we seen standing as being one of the defenses against bringing a claim? And two, what about governmental immunity?
Well, the answer to the first question is yes, and the answer to the second question I'll answer in just a second. As a matter of fact, the Hodge case went off on the ground that there was no standing. And there was no standing because there was not the requisite connectivity with the United States. Hodge was a non-resident citizen. He was a citizen of Somalia. And the property we were talking about was located outside the country. So the court held that the plaintiff did not have standing. The second question is, what about immunities? Yes, well, one of these cases, I think, I'm pretty sure it's the case in the Southern District, discussed the immunities issue at some length. And I don't remember the precise details now, but essentially it went like this. That is, governments, as we know, normally are immune to lawsuits, except when you satisfy certain conditions. Now, at the time that the FSIA, the Federal Sovereign Immunities Act was passed, Congress said that the governments and units like that have the same immunity as organizations had under the International Labor Organization Act, or something like that. And so there's still quite a bit of debate about that. It's discussed in some detail in the cases. But the way you get around that is to show that the governmental entity is engaged in a commercial act as opposed to a sovereign act. And in that case, you can bring the lawsuit using the Federal Sovereign Immunities Act as your basis for jurisdiction.
Any other questions related to our first two panelists? If not, let's give them a hand.
I have a question.
Yes.
Leroy, what effect does, like for instance, for myself, when I learn about things about Africa, that's because it's the English press, or it's being printed in English. I don't speak French. So I didn't even know that, that France was still actively involved with these French, they used to be French colonies. I thought that all of Africa was free and they had presidents and everything else. But now I find out that Africa's in there, France is in there, stealing all the money and paying them pennies on a dollar, pennies on, $100. So how do we get to the point when you make it known about all of Africa? Because we hear about South Africa, Nigeria, they speak, primarily English.
Well, this is the question that you're raising overall, I think, is one that I've been interested in for some time, and that is a lot of our communications have been with Anglo-speaking African countries, and so I've just asked the question: what about the Francophone countries? Mm-hmm. And now, one way that you can get French news, I guess you have to do it on the web. But there are African language news programs on television that have English subtitles. That's one way. The other is you look at the Pan-African Lawyers Union, And their announcements are in English and also in French to try to get people to try to be as broad as possible. Now, the reason that I know something about some of those things is because I live in Botswana. I get all kinds of news. I get French news, Russian news, Chinese news, Indian news, American news, local news. But I think what you have to do is to do it by trial and error. They used to have a website that listed all the international newspapers. And you could, for a given country, for example, let's take Nigeria. You could find the English version of the French newspaper on that website. So you have to search for these things. Now, I just want to address one other thing though, if I may, just briefly. I talked about the effort that was being made. It's not just the French that are doing these studies, it's the Americans, you know. However, the Americans relied a lot on records that were in France. They went to France, they looked at those records, they analyzed those records, and they made the report.
I just wanted to add, Leroy, you mentioned during your presentation that the value of Haiti reparations have been calculated. Also, by comparison, the value of reparations from African Americans having built the U.S. on their back, that's been calculated by economists to also be in the trillions of dollars.
Very quickly, this is fascinating because it will take you back to the geopolitical situation that existed during apartheid. One of the reasons that the UK, and I might say the United States, were so disinterested in having South Africa becoming free is because you had all these white states around there, Rhodesia and so forth. And so they said, no, several things happened. We cannot allow, for example, an interracial marriage to exist in Botswana because then it could affect what happens in South Africa and you have intermarriage and so forth and so on. With respect to the reparations issue, if one comes up with a viable mechanism for securing reparations from France, the United States definitely is going to start paying attention.
Thank you, and I think that discussion also leads us to something that we often don't want to address, which is the fact that as U.S. citizens, we need to stop being monolingual, that it is also incumbent on us to learn other languages as well. And I admit, I bought my Rosetta Stone, I just haven't applied it to my computer, but years ago I used to have conversations in French, so, but you know, if you don't use it, you lose it, so I'm working on it. So with that, at this point, I'm pleased to bring to you two people who are multilingual and who are involved in a very important effort, which is the African Continental Free Trade Area, which is Africa's, is it correct or not correct to say that the AFCFTA is Africa's version of the World Trade Organization? Okay, sort of. But its implementation will then create the largest trade market on the globe of the United States.
What's the name again?
African Continental Free Trade Area. You will see the initials capital A, small f, capital C, capital F, capital T, capital A. So if you go to the African Union website, look up AFCFTA, then it will give you all the information. This is a very exciting development on the continent of Africa, and due to Ms. LeBlanc, Johanna LeBlanc, the NBA has the opportunity to sign an agreement with the AFCFTA, which gives us the opportunity to be on the ground level and to, as opposed to after the fact, complain about why nobody brought us in and look how all those other people are at the table. This is our opportunity to step up, so we are now at the stage of developing a work plan, and then we plan to work it. So it's my honor, and the Secretary General, it says a lot that he sent his high-level representative here to America to be with us, just to be with us. And so I will call up Ms. LeBlanc and Ms. Okala, and they will then lead the discussion, and then we can finish with the discussion with them. Thank you.
So I prefer to use the microphone.
Oh, please.
I'm trying to find my campaign voice.
Watch yourself.
All right. Good afternoon, ladies and gentlemen. Good afternoon. It's my pleasure to be here representing His Excellency, the Secretary General of the African Continental Free Trade Area Secretariat, the AFCFTA Secretariat. The Secretary General has a good work relationship with the Bar Association, and we're looking forward to formalizing it by the conclusion of an MOU. And I'd just like to give an overview of what the AFCFTA agreement and the AFCFTA Protocol on Investment is about. The AFCFTA agreement is an agreement that moves for the liberalization of the African economy and the entire African continent. It's an agreement that was inspired by Agenda 2063 of the AU heads of state and government. And one of the primary things they wanted to do in integrating and promoting intra-African trade and prosperity within the continent is the AFCFTA agreement. The AFCFTA agreement came into force in 2018. It is currently in force, and the agreement has a couple of protocols to help in easing its implementation. The first three protocols formed phase one of the agreement, and those protocols are the protocols on the trade in goods, protocols on trade in services, and the protocol on the rules and procedures for the settlement of disputes. The AFCFTA agreement provides for phase two protocols, which actually help with the granular details of implementation. And those protocols are the protocols on investment, the protocols on intellectual property, protocol on digital trade, and protocol on women and youth. All these protocols have now been concluded. In February of this year, the protocol on investment was finally adopted. It was adopted last year in February by the Assembly of Heads of State and Government, but there were two provisions that needed some extra work. So it was more or less adopted in principle. But in February this year, the entire text was adopted finally, in addition to the protocol on digital trade and the protocol on women and youth. For the protocol on investment, it changes the game in Africa, for investments in Africa. It is a protocol that drew inspiration from the best of African investment instruments. And the primary one at the time was the Pan-African Investment Code, I beg your pardon. It was also inspired by UNCTAD's investment policy framework for sustainable development. I had mentioned during my keynote in the previous session that the protocol sits on 4 key pillars: investment promotion, investment facilitation, investment protection, and sustainable development. Investment promotion is self-explanatory. Investment facilitation mirrors largely the conversations going on in WTO under the Investment Facilitation for Development Agreement. Investment protection, as we might be familiar with, are protections around national treatment, most favored nation, guarantees against expropriation, guarantees for transfer of funds, which is very important as well. And then the sustainable development angle of the protocol, the pillar, introduces it balances out, I like to put it that way, it balances out the asymmetry between investors' rights and obligations. So it speaks to the developmental aspirations of the countries on the continent, in addition to the profit expectations of investors. So we have provisions on environment, public health, labor, human rights, anti-corruption, responsible business conduct, and the like. Climate change, in particular, as well. The protocol also establishes a Pan-African Trade and Investment Agency, which is supposed to help with actual implementation after the policy formulation has been concluded. That agency was approved, established with the adoption of the protocol, but it is yet to be operationalized. Pending its operationalization, the AFCFTA Secretariat is supposed to be carrying out its functions, which are 5 primary functions, the 5 fingers of a very healthy hand. Image building for Africa, investment promotion and generation in promoting Africa-specific projects. Investment facilitation is supposed to serve as a repository for investment information, investment projects. And then policy advocacy is to interface with organizations, associations like the MBA, find out what the concerns are about investing in Africa, and helping to escalate these concerns to the highest level on the African continent. And then the 5th part of its functions is capacity building for investment promotion agencies. One thing I did not mention earlier was the fact that the Protocol on Investment has 2 annexes. The first one is on this Pan-African Trade and Investment Agency that is currently being negotiated. And the second annex is the annex on the settlement, on the management and settlement of disputes. It is an ongoing process. It's a member state-driven process. But chances are, without spilling the beans, chances are there's going to be a lot of ADR as part of that. Because we are trying to see how we can do a lot of dispute prevention and then management of the disputes, see how we can do be amicable resolution of a number of the disputes, and then it has a very strong ADR component in there. The protocol generally also helps with coordination of regulations on the African continent, and it requires that within 5 years of its coming into force, the investment laws and regulations of all African states should align with the protocol. Similarly, the protocol is supposed to, upon coming into force, replace all intra-African bilateral investment agreements. And finally, within 10 years of its coming into force, it is supposed also to, the regional economic communities are to align themselves with the protocol. In terms of going forward, what do we need to do? Having gotten this document, implementation is the next step. But for state parties, ratification, domestication of the protocol will be the first step. And once that is done, we will start implementing. The AFCFTA is currently engaging with different groups, different levels of strategic partnership and the state parties to see how we can translate this fantastic policy document into actual economic gains on the continent. And we're looking forward to working with the MBA even more closely as we achieve this. I thank you for your kind attention.
Good afternoon, everyone.
Good afternoon.
Wake up. I know that you guys are tired. Some of our sessions started as early as 7:30, 8 o'clock in the morning. So I'm not going to make this too long because I think that, one of the things that Ms. Barbara is very keen on is having the people in the room with the expertise to speak on matters that pertains to them. They say that, be the voice of the voiceless, but sometimes we need to allow the voiceless the opportunity to speak up. But with that being said, I couldn't think of a better person to be able to speak for the AFCFTA than Patience. But I'll add a few things. With a continent of 1.4 billion people and with an average age of 19 years of age, I always say this: Africa's greatest resources beyond the minerals are its people, its youth. So when you see that within the AFCFTA, there's protocol that ensure that women and youth are included in this process, it just tells you how visionary that the Secretariat is. And when we think about the Secretariat, I think it falls in the same line with the likes of Thomas Sankara, right? Kwame Nkrumah. This is a game changer for the African continent that will change the trajectory of the continent. And according to the World Bank, it is estimated that through the implementation of the AFCFTA, we will be increasing the GDPs of African countries collectively in the billions, if not more. Was it billions or the T? Is it billions? In the billions. And we were to lift millions and millions of people out of poverty. And I don't know if you guys have noticed this, but there was a time when we talk about Africa, it was about human rights violations, it was about illnesses, it was about corruption. But maybe it's in the line of work that I'm in, but there's been a shift, even in Washington. The focus is now on trade and investment. And that is really the only true way that we're going to lift the continent towards economic prosperity. It is through this trade agreement. It is through investors going on the continent and to do business, right? And having the confidence that their investments will be protected by protocols such as the investment